Now, the court came to a conclusion that in the first place, it said, an analysis is required to be undertaken of the provisions in the Patents Act and the Drugs and Cosmetics Act and the Drugs and Cosmetic Rules. Under section 13(4), it recalled, of the Patents Act, the grant of the patent shall not deemed in any way to warrant its validity, and no liability shall be incurred by the central government in connection with any examination or investigation or any report or proceeding consequent thereon. In other words, a patent has been granted to an applicant, can be challenged on various grounds in accordance with the Patents Act. So, hence the court came to a conclusion that, and reading Bishwanath Radhe Prasad Shyam's decision in Hindustan versus Hindustan Metal Works in 1979, it said that it is a well settled law that grant of patent does not guarantee its validity. So, based on this, they said that section 48, which has been expressly made subject to other provisions of the Act, confers on the patentee, both where the subject matter of the patent is a product or a process, the exclusive right to prevent from making, using and doing other things in relation to the patents in India, which are specifically provided in section 48, but it said it is a negative right which is enforceable at the instance of the patent holder and only subject to other provisions which permit challenge to the validity of the patent to be raised as a defense in case of suit for infringement. So, this the court said is evident from section 64 and section 107, section 64 dealing with revocation of patents and section 107 dealing with defenses for infringement. Therefore, it appears, the court said, that in relation to any steps that a patent holder might wish to take protect the patent from being infringed, resort should be had only to the provisions of the Patents Act. Now, the court also said that although much emphasis has been laid down under section 2 of the DCA to suggest that this provision requires the DCGI to account for the Patents Act, since provisions of DCA are expressly stated to be in addition to and not in derogation of any other law for time being in force. Now, this submission, the court said, proceeds on a misconception that the DCGI is required to account to the provisions of the Patents Act. The reference to section 156 that patent shall bind the government, or as it reads, a patent shall have to all intents the like and effect as against the government as it is has against any person, does not mean that the DCGI has to enforce and protect the patent for the product in respect of which marketing approval is sought from being infringed. Now, the court said section 156 only states that the government cannot also infringe a patent. It is a negative obligation on the government not to infringe. It creates no duty or positive obligation on the central government or any department thereof to protect a patent from infringement. Now, this reasoning seems logical because it is well nigh impossible for the government to actually look into the motives of private businesses and look into whether they are infringing. Now, infringement actions can be always taken as private actions or civil actions under the Patents Act, and such actions are to be taken by the patent holder himself. So, the court, by looking into the wordings of section 156, clearly said that there is no positive obligation on the government to prevent private parties from infringing, and this seems to be quite logical. Paragraph 22 of the decision also reads that in granting marketing approval to a patented drug, the DCGI is by no means itself infringing any patent or abetting the infringement of any patent by the applicant in whosoever favour the marketing approval is being granted. Such an argument proceeds on the misconstruction of the scheme of DCA. The object of the DCA is to regulate the import, manufacture, distribution and sale of drugs and cosmetics. The numerous amendments made to DCA, including the ones made in the 1982 amendment, which widened the definition of drugs or patent of proprietary medicine and introduced the concept of spurious drug, did not require the DCGI to itself enforce a patented drug under the Patents Act and deny marketing approval to a generic version of the patented drug manufactured by the patentee. Now, such claims were being made by the petitioners here that granting permission would actually can be construed as granting permission to spurious drugs, and that is why they said that there is no such connection. One of the important issues in relation to other forms of intellectual property is the protection of non-original databases. Some jurisdictions like the European Union have specific directives relating to non-original databases. Now, what are these non-original databases? As per the WIPO, the originality requirement that a database must constitute an intellectual creation by reason of selection or arrangement of its content in order to enjoy copyright protection means that some databases are not protected under copyright, even if substantial investments have been made to produce them. It means the logic seems to be investment protection. It has been discussed whether such investment should be protected, for example, as a sui generis right. Another possibility is to use approach based on protection against misappropriation of or unfair competition. Now, the WIPO seems to give kind of choices of how to come out with the protection for non-original databases, because there is sufficient investment, but it can't constitute original in the sense because there is no originality in the content itself, but there is originality in terms of selection and arrangement, which is otherwise protected as a compilation under the Copyrights Act. So, how do we protect these other categories of rights that might be associated with a significant amount of investment being made by the people who are investing in databases? This has huge long term implications both in the computer industry, in the biotech industry, and several other industries which routinely rely on large data. Non-original databases are not protected in India. Original databases are protected under the Copyright Act, but some courts in decisions point towards instances of protection of such databases. In Burlington Home Shopping versus Rajneesh Chibber, this is the 1995 decision of the Delhi High Court, there was a question whether certain types of compilations should be protected. Now, here the court said a compilation which may be derived from a common source falls within the ambit of literary work. It also said a work of compilation of a nature similar to that of another will not by itself constitute an infringement of the copyright of another person's work written in the same pattern. Then it went on to say that the question whether an impugned work is colorable imitation of another person's work is always a question of fact and has to be determined from the circumstances of each case. Fourth, it said the determining factor in finding whether another person's copyright has been infringed is to see whether the impugned work is a slavish imitation and copy of another person's work, or it bears the impress of the author's own labor and exertions. The aforesaid principles are by no means exhaustive. That is what the court said, but the ratio of the decision seems to be in this particular paragraph. It said, and I quote, "From the above statement of authorities and trends of judicial opinion, that is clear, it is clear that a compilation of addresses developed by anyone devoting time, money, labor and skill, though the sources may be commonly situated, amounts to a literary work wherein the author has a copyright." Now, the logic of this decision seems to be that wherever there is an argument for sufficient investment that has been done by the plaintiffs, then naturally, and if there is it is found that there is a slavish imitation, it should not matter whether the basis is statutory, the court can go on and protect such kinds of databases. Now, this seems to be a per incuriam decision in the light of several other cases, including the recent decision of Eastern Book Company versus DB Modak, the Supreme Court decision, wherein the court has said that there is some level of modicum of creativity that may be required, and what is not protected is the sweat of the brow. So, in the light of subsequent decision, how far Burlington Home Shopping decision is valid in law is a question. Finally, utility models is another regime that has been prevalent in many jurisdictions, but India does not definitely provide for utility model protection. The patent system requires invention to comply with novelty, inventive step in industrial application and disclosure. Now, this leaves many inventions out of the gear of patent protection. Largely these are incremental workshop improvements in nature made by firms, large number of small and medium entities, micro entities, and these do not qualify for patent protection because the threshold for patent protection is quite high, especially the inventive step standard. Now, what does the UM then allow? The utility models allow a right to exclude for such inventions by diluting the criteria of inventive step and by fastening up the process of grant of utility model certificates. Now, there are various mechanisms as to how you should evolve or how you should resolve the issue of overlapping of rights, and different jurisdictions have evolved the models differently because there is a lot of flexibility. Primarily because these utility models are clearly not required by the TRIPS agreement, there is no specific obligation that exists in the TRIPS agreement pertaining to utility models. However, Paris Convention uses utility models within the domain of industrial property because the industrial property definition in the Paris Convention is quite broad, But it is important to note that Paris Convention does not clearly require to give effect to such provisions. What is required in the Paris Convention is, if you have, then you should comply with the national treatment provision. Similarly, in the TRIPS agreement, now read mutatis mutandis, along with the Paris Convention, you would require that both national treatment and most favored nation treatment are given effect to. But there is no positive obligation to implement UMs or utility models as such. Which are the countries which have utility models? China, Germany, Japan, Australia. These are some of the countries which have utility models, and there are several others which have enacted such utility models, but these are examples where they have published reports and have come out with arguments in either in support or conveying a mixed feeling of how the utility models legislations have worked in these countries. There is a recent development in this regard. Recently, the draft national IPR policy has recommended that in 2014 that India may want to look into the protection required for utility models. In summary, we have discussed how new and emerging forms of intellectual property or other complementary rights are changing the emerging landscape of global IP regimes and Indian IP regime. We have looked into the legal and conceptual basis of such regimes by way of examining specific legislations like the Semiconductor Chip Act. We have also looked into several decisions involving unfair competition. We have looked into the demands for data exclusivity, looked into the concept of patent linkage, which has been rejected in India. We have looked into the concept of non-original databases, which are not statutorily provided in India, but yet some of the judicial decisions point towards the direction of non-original databases. We have also looked into the need and the demand for utility models legislation. We have looked into and located these acts and these regimes in the context of India's statutory and case law jurisprudence evolution. We have discussed the common policy implications of having such regimes. With this, we conclude the module. Thank you very much.